Before you recommence your submissions, I would like to indicate that the board would find it very useful if those instructing both parties were to have a look at the chronology and expand it to fit into it the various references that have been discussed today. That will involve, Mr. Fitzgerald, I imagine, listening to your submissions and slotting in the various passages.
Well, I did have a speaking note, but since your lordships don't allow speaking notes nowadays, you can't have the. Who would have had it?
I'm not inviting a speaking note, for which thank you. But if that could be done, and submit to us a revised chronology.
Yes,
that'd be terribly useful.
Of course. Might it be convenient to omit some of the matters from the chronology that might be a bit extraneous, or should we assume that you want things added, nothing taken away?
Well, I don't think you need to omit the extraneous. It's just that we have
Make a mistake. You might omit something that we didn't think.
Well, that's true. I suppose we might think it's...
We would solve one problem and create
we seem to be shuffling between three different documents to get the basic chronology, and it wasn't altogether helpful.
Unsatisfactory, I agree. But
yes,
no, we weren't...
I've expanded rather than a reduced chronology.
Okay.
Thank you so much.
My lord, of course, yes.
We won't take anything out in case we think it's extraneous and your lordships don't. My lord, before I get on to what I propose to do really is to focus principally on the judgment of the Court of Appeal in my submissions. But before I get on to that, may I just finish off what I was saying briefly about the law? And I wanted to try to disentangle, to some extent, two aspects which I touched on before the short adjournment, one being the substantive law and the other being the approach that an appellate court ought to adopt in a case like this. One further point just in relation to the substantive law that I wanted to pick up, because it's relevant to the way in which the Court of Appeal put the matter, is what was said by the High Court of Australia originally in the Ebner case and subsequently in a more recent case about the process by which one addresses the question of what a reasonable onlooker would think as regards the possibility of bias. My lord, this is in the thing called supplemental electronic bundle, which I hope the board has. We seem to have slightly bedeviled in this case by matters not reaching the board, but I hope this has already found its way.
This is Charistes.
That's right, yes.
Yes, we have that.
That's right. Charisteas and Charisteas, a quite recent case of the High Court of Australia. I needn't go into the facts because they're peculiar to that case and of no particular relevance to ours, but at page 9 in the electronic bundle, we see the High Court setting out the test in Australian law. Your lordships will see there the apprehension of bias principle is that a judge is disqualified if a fair-minded lay observer might reasonably apprehend the judge might not bring an impartial mind to the resolution of the question that the judge is required to decide, which is broadly the same as the test in Trinidad and Tobago and indeed in all the United Kingdom jurisdictions. But the court goes on to say the principle gives effect to the requirement that justice should be both done and seen to be done, reflecting a requirement fundamental to the common law system of adversarial trial, which of course one can't dissent from that. Then they go on to say its application requires two steps. First, it requires the identification of what it is said might lead a judge to decide a case other than on its legal and factual merits. And second, there must be articulated a logical connection between that matter and the feared departure from the judge deciding the case on its merits. Once those two steps are taken, the reasonableness of the asserted apprehension of bias can then ultimately be assessed. All of which is quoting from the case of Ebner, which is cited there in the footnotes. Ebner against official trustee in bankruptcy, a case from 2000. That isn't, of course, quite how it's put in our law, but in my submission, it's essentially broadly the same. And really, what it does is to spell out in explicit terms what is implicit in the way the test is put in the Judicial Committee's jurisdictions and in the Supreme Court of the United Kingdom's jurisdictions, namely that the process that the reasonable observer will follow necessarily in deciding whether there is reasonable ground for a reasonable apprehension of bias is one that involves looking at going through those two steps, looking at those matters and going through those two steps. What is it that is said to lead the judge, and is there a logical connection between that matter and the feared departure from impartiality?
Yes, I mean, you're not suggesting that we should depart from the Porter and McGill test.
No.
But you're saying that there are two steps to be undertaken, however you articulate the test.
Yes.
Thank you.
Yes. So, my Lord, I think that's all I wanted to say about the substantive aspect of the matter. I touched already before the short adjournment on the position of an appellate court and on the position of this appellate court in particular, by reference to the Das and Marchand case. And although these are quite familiar principles, but may I just take the board very briefly to that case. This is in the authorities bundle. My Lord, if we to go straight to the passage I want to rely on, it's at 3616. I mean, there are plenty of other cases saying broadly the same thing, but since the law reporters have called this case practice note and put it in as an example of the board's practice, or an example of the board setting out its practice, it may be convenient to go to it. Section 5, the reasoning of the board as to why the appeal should be dismissed. Skipping over what I take to be the compliment.
It is a compliment.
Well, I think the subordinate clause sugars the main rather. But anyhow, then we go on to the substance of it. The general practice and the reasons for the general practice, which is really what's important. Halfway through paragraph 16, two main reasons. First, the trial judge, and a lot of this course is about seeing and hearing witnesses of fact, which is not directly relevant, but where those findings of fact have been upheld by one appeal court, there is no reason to think that a second appeal court, the third court looking at the facts, is more likely to be correct about the facts than the two courts below. Secondly, the Privy Council wishes to respect factual circumstances peculiar to the country from which the case comes, especially, for example, local customs, attitudes and conditions. And the first instance and appeal court judges in those countries are very likely to be in a better position to assess such factual circumstances than is the board, which is an observation of the board that one suspects Lord Burrows had in mind in the course of intervening earlier on my learned friend when he was addressing the legal test. So, my Lord, I accept, of course, as my learned friends do, that is, as my learned friends say, that is not directly on point in the sense that, as I've already said, we're not dealing here with an appeal on a question of fact. But it's, in my submission, clearly pertinent to keep in mind the position of the board in relation to questions of local customs, attitudes and conditions. So, may I then turn, my Lord, back to the judgment of the Court of Appeal. And if I can spend a little bit of time on that, I'll seek to explain why we respectfully submit that that is a judgment which the Court of Appeal was entitled to reach and which it would be right for the board to leave in place. Its structure is, as the board will have noticed, to start with a summary and then to go on to give details, although in fact the summary itself contains some details of the reasoning, so one needs to look at both. Picking it up, if I may, at 169 in the electronic bundle, paragraph 60, under the heading Summary. This is after the bit we looked at before the short adjournment, where they do talk about the judge being entitled to decide as he did. It's set out there, that Justice of Appeal Rajkumar sets out there the various reasons why the basis of the apparent bias is alleged to arise, and at least in broad terms, those are essentially the same arguments that are advanced before the board today. Then we see over the page, or down the page, on 170, Justice Phil Rajkumar goes straight to the findings of the Court of Appeal in Pandey and Virgil. And says at 61(1)(a), end of the first substantive paragraph, having referred to the Pandey and Virgil case. While there were comments on the conduct of the Chief Magistrate, those findings of apparent bias by him were in relation to the matter involving the appellant in that case. Therefore, those comments and findings bore no obvious relationship to the proceedings involving the instant appellants. The learned judge goes on, all those findings and comments were public by the time of the institution in July 2007 of the previous proceedings for judicial review by Maritime General and Fidelity Leasing before Justice Tiwari Reddy and the Court of Appeal. That was their, as your lordships will recall, that was their judicial review of the decision that to reject the no case submission. No issue was raised before the Court of Appeal in those previous proceedings for judicial review filed in July 2007 that the decisions of the Chief Magistrate in relation to the decision that he took on the 9th of July 2007 affecting the first and second named appellants were influenced by his being beholden to the then Attorney General.
And do we have in the bundle the decisions of Tiwari Reddy, Justice Tiwari Reddy in the Court of Appeal?
I think that's one of the things that's been omitted that we ought to put right, if I'm right.
I mean, I think we better see.
Yes, absolutely. I mean, it's quite right.
That's being referred to here.
But the judge goes on that we're prepared to accept in principle matters which in July 2007 may not have sufficed for a bias challenge could have been supplemented by further matters which tip the balance in favour of launching such a challenge. The issue, however, is whether that in fact was the case here. He says issues of waiver and estoppel don't arise. We are persuaded that it's appropriate to examine, top of the next page, whether the matters raised in Pandey and Virgil were by themselves or in combination with the other matters outlined below sufficient to justify an allegation of apparent bias requiring recusal. I emphasise whether in combination with the other matters outlined below sufficient, because I think one of the criticisms, although my learned friend didn't emphasise it in his submissions today, has been that they didn't take account of the full picture, didn't take account of the confluence of pressures, as I think it's been called, in the appellant's case. But in my submission, the Court of Appeal plainly did. Then there's reference to what they describe as matters subsequent to the decision of the Court of Appeal. The revelation that the Chief Magistrate had in fact immediately deposited the cheque, a fact that had not been previously revealed, and that the certified copy of the deed for the land that he claimed had been given to the purchaser was dated months after he had returned the cheque and cancelled the sale transaction. It'll be obvious, I hope, from my submissions that it's plainly no part of what I seek to do in these submissions to seek to explain away every aspect of the Chief Magistrate's conduct. That's neither the role of the respondents to this appeal in principle, nor in any event something which it's practicable to attempt to achieve. But the question is, how do these matters affect the present proceedings, and were the Court of Appeal entitled to conclude as they did in these proceedings that whatever one could say about the Chief Magistrate in relation to the other proceedings, it didn't justify
well, it was a pretty big difference for a start, wasn't it, that on the evidence that the Chief Magistrate himself had given now before the Mustall Tribunal, instead of, as he'd previously claimed, sending back the cheque at once because he thought, oh, there's something funny about this, he had solicited the payment himself immediately after the witness gave evidence, banked it, and only sought to return it when the bank created a problem. I mean, that just blew a hole in his integrity and in his credibility. Just alone, before you get on to the Attorney General.
Well, undeniably, my lord, what your lordship says is right. I'm not sure I can. There isn't sensibly anything that I can say by way of riposte to that, as it were, notionally on behalf of the Chief Magistrate.
How can he continue in proceedings against effectively co-defendants without somebody thinking, well, now he's going to want to be showing that he wasn't influenced by the bribe that he accepted and then returned in the previous case. Now he's dealing with the other people out of the very same airport corruption.
Well, the issue, what it comes to in my submission, the issue which the Court of Appeal looked at, and I'll take the board back in a minute to what they said about this. The issue is the degree of linkage between the different matters. There's a separate point which my learned friends take about whether in the abstract one might say that the Chief Magistrate was, by his conduct, disabled from deciding essentially any case, the moral authority point. Yeah. And I'll come back and deal with that later on, although your lordships will have gathered what I say in relation to that is that there is no separate doctrine that allows the court to say of a judge who is still a sitting judge and who has not been removed by the constitutional processes for removing a judge, oh, well, he's so compromised or she's so compromised that no more sitting is permitted. There isn't such a mechanism. But I'll come back to that point subsequently. But so far as the common law challenge on bias is concerned, the question for the courts below, which the Court of Appeal dealt, was what is the extent of the linkage between the matters in respect of which the Court of Appeal found the Chief Magistrate's conduct to be compromised. No doubt Your Lordship will say if I don't, plus the additional revelations since, and the present case. And that's what the Court of Appeal does deal with, and as one can see at the top of 171, that's what Justice of the Appeal Raj Kumar essentially directs himself. So the Court of Appeal perfectly frankly accepts that there are, as they describe it, revelations from the Mustard Tribunal, and sets them out at little 2a. And then...
Is it really fair to say, I'm looking at the bottom of page 171, that the subsequently revealed details of the matter in relation to what had been identified in Pandey and Virgil had nothing to the fundamental finding of the Court of Appeal? And the subsequently revealed matters were, in particular, the testimony of the Chief Magistrate for the Mustard Inquiry. I mean, might it not be thought that that actually put an even more serious, shone a more serious light on what had happened than had been perceived at the time of the Pandey judgment?
Well, not entirely, my lord, because in a sense, what the Court of Appeal found in the Pandey matter was an appearance of bias by virtue of the matters that it referred to. What you then get from the Mustard Tribunal is the revelation, as the Court of Appeal put it in this case, that what had happened was somewhat different in relation to the money. But it doesn't. I mean, it doesn't. In a sense, once you're shot on the first one, it doesn't make it that much worse that it turns out the explanation is.
That's what I'm questioning, because what appears from the evidence to the Mustard Inquiry is, as Lord Legate was putting it to you, that the Chief Magistrate had himself solicited the payment, had in fact seemed to take the payment, and it was only when others raised problems with the payment that he sought to return it. That might be said to put quite a lot more serious complexion on what had happened.
Well, I'm not sure it's right. Well, I'm not sure it's right. The Mustard Inquiry says that, or finds that he had solicited the payment. I think that's the issue that's. I mean,
well, that was the gist of his evidence. That's what he said, that he had gone out at lunchtime and called Mr. Maharaj and said, could you please pay the deposit? Sooner the better, please. And then it was brought round to the court the next morning. That I accept. What I had in mind was whose original idea was it that the money be paid? Because I think the evidence was that, whether one accepts it or not is a different matter, but the evidence was that the original suggestion, yes, there will be a purchase of this land, we're prepared to purchase the land, had come from a phone call he had received from Maharaj. That's what I had in mind. Yes, I see. But I mean, yes, of course, I accept that it clearly makes the matters in the Pandey matter worse to some significant degree, it might be said, because once it becomes apparent that having received this money, he went straight to the bank and deposited it. I mean, there's nothing one can say in defence of that. But one comes back to the question of whether really the issue is whether the fact that he behaved deplorably in the context of that matter means that he is unfit to sit, or rather is to be deemed to be on the basis of apparent bias, not an appropriate person to deal with this matter.
As we noted earlier today, the Pandey conviction occurred relatively early in the course of the series of the main events, and I can well see that you would be able to say that at that stage that conviction was quashed because of the desirability in the Chief Magistrate's mind to keep the Attorney General on side, having recently confided in him as to what had happened and what he'd done. The difference by the time of the current case is that the Chief Magistrate's desires had been fulfilled, perhaps beyond his wildest dreams. The Attorney General had done all he possibly could, A, to shut down the investigation, and B, dig the Chief Magistrate out of his financial problems. Now, does that not put the Chief Magistrate in a position of clear indebtedness towards the individual, never mind political directorate, the individual in charge of the Piarco 1 prosecution?
Well, plainly one can, I mean, yes, one can see exactly why that proposition is put, and there's not a great deal I can say in response to it. Realistically, I accept that, but it's nevertheless necessary, in my submission, to do what the Court of Appeal did, which is to look at the extent to which any degree of being beholden to the Attorney General, any gratitude that he might have had to the Attorney General, translates into the well-informed observer saying that in relation to these specific appellants on this specific charge, there is reason to fear that the Chief Magistrate won't deal with the matter impartially. I mean, one might envisage a case where it said, well, it's so strong so lamentable are the circumstances that this judge can't be trusted to try any case involving anything to do with the state, for example. Maybe it's Malone and Friends' case that this is such a case. I don't know, but one has to look at it in relation each time to the specific facts of the specific case. And what the Court of Appeal was seeking to do in its judgment here, which we respectfully submit they were entitled to do, is to ask whether, granted all that we know about the way the Chief Magistrate had behaved in the previous matter, does that affect, in the eyes of the reasonable observer in this jurisdiction, with knowledge of this jurisdiction, etc., his ability to continue as magistrate?
Well, isn't it obvious that the Attorney General will be happy even if he hasn't managed to secure a conviction against the Prime Minister and leader of the opposition party for corruption in the construction of the airport, if he could get at least get a few convictions against other people involved in that, some of whom also one of whom was actually, I think, the treasurer of the or financial officer of the party, and other people who had links to the opposition. I mean, a partial observer doesn't live in fairyland.
No, of course not. I accept that, my lord. But one needs to be careful in my submission about treating all of the appellants, as it were, as if they were all in the same position. These are the charges against these appellants are that in their capacity as business people, they have suborned they suborn the Minister of Finance to get a personal advantage. It doesn't necessarily follow, and this in my submission is a weaker aspect of Malone and Friends' case. It's not nearly as straightforward as saying simply, well, they're all essentially part of the same team, so therefore, of course, it would please the Attorney General to get a conviction. I mean, it will always, I suppose, please an Attorney General to get a conviction, because the Attorney General is ultimately responsible for prosecutions, and no doubt if the Attorney General thought that a prosecution was really ill-founded, then he or she would step in and stop it. So in that sense, if one's going to say that in any case where one can show any sort of indebtedness, or indebtedness is the wrong word, gratitude, perhaps on the part of a judge towards the Attorney General, then that judge can never sit in any case involving the Attorney General. Then, I mean, if one wants to put it in those absolute terms, then that's that as far as this case is concerned. But what the Court of Appeal was looking at was the specifics of this case against these appellants.
But, I mean, we've been shown enough to make it clear that the Attorney General wasn't sitting impartially aloof from all this. He entered into the arena and expressing views, for example, about the case and the way, and was in personal ultimate charge of it. And one can't ignore the fact that he was a political appointee and the Minister of Finance was on the other side of the political divide.
No, my lord, that's of course entirely fair. But one has to separate out the different elements of that. The comments that the Attorney General had made, I think this is another of the documents that are yet to be supplied, but as we heard in the course of my learned friend submissions, were themselves subject in the context of the extradition proceedings, looked at by the Court of Appeal, who said essentially they were overzealous but didn't cross the line to the point where he was disqualified on the grounds of bias from giving the go-ahead to the extradition. It's a truism of any constitution on the Westminster model that the position of the Attorney General is an anomalous one in some respects, being both a politician and a law officer. And clearly, if one looks at purely the aspect in which, the respect in which the Attorney General is speaking on behalf of the state about the case, one can see why the Court of Appeal said that he was overzealous in what he said in the press about these not about these defendants, but about the Piarco matter generally. But one has, in my submission, still to draw it back to these appellants and this case, and can one say that this magistrate, is there a reasonable possibility that this magistrate is there a reasonable possibility that he would so disregard his oath as to be inclined to commit for trial whatever the merits, which is the right way to look at it. And my lord, can I just take the board through the way in which the Court of Appeal looked at the matter? Because
I'm sorry to interrupt.
No, not at all. I anticipated you might.
Before you do, can I ask you about this, the structure of Justice of Appeal Raj Kumar's judgment? So I'm looking at page 170.
Yeah.
Where he deals first with the findings of the Court of Appeal in Pandey and Virgil. Point A is the comments bore no obvious relationship to the proceedings involving the instant appellants. And then he makes a point that in the judicial review proceedings in July 2007, no issue was raised before the Court of Appeal in those previous proceedings for judicial review about bias. And it seemed to me that the Justice was treating that as the base point for his analysis later on. And I wonder whether that's really correct, that he should do so. I mean, if people didn't raise a question of bias in those proceedings, the Court of Appeal simply wasn't invited to address it there. Whereas when one then goes on to the matters subsequent to the decision, so at the bottom of page 170, the Justice of Appeal says, well, I'm now going to look at whether additional things, when added to the position in Banjay, create the impression of bias. But again, it seems to be against the background of him saying that the starting point, the base point, if you like, is just on the basis of what was known in relation to Panjay, no impression of bias, because when one looks at the bottom of page 171, we see the reasoning is the revealed details, what I was asking about before, the evidence of the Chief Magistrate to Mustel, add nothing to the fundamental finding of the Court of Appeal in relation to Pandey and Virgil, and therefore the implicit reasoning is, and therefore that can't ground a complaint of bias either. In other words, the starting point is actually nothing wrong if you look at the position as it obtained in 2007. Let's see if anything that happened after that has made a difference to the position. And I wonder whether that's actually the appropriate way for the court to have looked at this.
Well, my lord, I can entirely see with respect why your lordship says that, but I'm not sure that I would accept that that's quite fair as an analysis of how the learned justice deals with the matter. I mean, he makes the point that in B that Maritime General and Fidelity Leasing hadn't taken a point about bias, but then goes on to say that, as you see at the bottom of 170, we're prepared to accept in principle that matters which in July 2007 may not have sufficed for a bias challenge could have been supplemented. So I agree. I accept
that rather makes the point.
I agree at that point.
Perhaps they could have sufficed. It's just that no one argued it.
I agree that on its own that does suggest that he's saying exactly that. But really, then it needs to be something further. But in fact, if one looks at what he goes on to say at the very next paragraph, we're persuaded that it's appropriate to examine whether the matters raised in Pandey and Virgil were, whether by themselves or in combination with the other matters outlined below, sufficient to justify an allegation of apparent bias requiring recusal. And then the matters outlined below are the subsequent matters. So the court does say whether by themselves. So that the question is being it's not being. I would suggest that the better reading of that is actually that the court is addressing. I haven't gone back, I'm afraid, to check in the transcript whether this is right on the facts, but it looks as if the court is addressing a submission. Well, look, they didn't. These people didn't take the bias point, so that indicates that they thought there was nothing in it. And far from accepting that as the baseline, is actually saying, well, no. The fact that that wasn't taken then is not determinative either way, because we need to look at whether the matters raised in Pandey and Virgil were, whether by themselves or in combination with other matters, sufficient to justify an allegation of apparent bias.
Yes, thank you.
This is all, of course, in the context of the summary, which in fact goes on at some length, but then is recapitulated to a certain extent in the detailed section. But just sticking with the summary for the moment, I've got as far, I think, as the bottom of page 171, top of page 172. 172 deals with the alleged conversation with the then Chief Justice, volunteered by the Chief Magistrate in the testimony to the Mustell inquiry. Pay attention to the prosecutor. And that's dismissed on the basis that it could not have led, even if it was made, could not have led any reasonably well-informed observer to conclude that it could have any bearing or influence, whatever, on the actions of the Chief Magistrate in July 2007 or January 2008. And
I don't think Mr. Fitzgerald is really founding very strongly on the question of the Chief Justice standing Lord Mustell's assessment of that particular aspect of this sorry saga.
No, and in my submission, my Lord Marlene's friends are right not to place much emphasis on that, because even if the allegation is right that that's what the Chief Justice said, really, in my submission, so what? I mean, it's one observation about paying attention to what one counsel says, but it doesn't. One wouldn't by itself. One would never, in my submission, think, well, that must mean the judges, in some way, lacking in impartiality. Then he goes on to deal with the disciplinary proceedings. Makes the point about the constitutional independence of the JLSC from the executive branch, and the lack of connection with any prosecution. It says that the reasonable observer would dismiss that as a factor. And over the page, any contention the Chief Magistrate may have wished to please the Commission by either hastening or protracting the committal proceedings against these appellants must first provide a plausible explanation as to how either approach by the Chief Magistrate could demonstrably achieve or produce such an effect, given the independence of the JLSC from these proceedings, and given further the fact that these proceedings related to his failure to testify against the then Chief Justice in an ostensibly unrelated matter. And in my submission, that's also entirely right as regards those proceedings. They are, in a sense, if anything, they rather cut the other way. One might have thought the reasonable observer would think, well, a judge who's under investigation by the Judicial and Legal Services Commission, who have said that they seek to interdict him, albeit he's challenging that by a judicial review, is rather more likely to be assiduous to stick to his oath than a judge who is not in that position. But at any rate, it's a point that goes both ways at best in my submission. Then the Court of Appeal, through Justice Phil Rajkumar, picks up the reference to the Mustell inquiry and says that it has nothing to do with the allegations have nothing to do with the instant appellants. Then he deals with this question of lack of credibility or moral authority, which is a different point. And then we get, after that rather long summary, in fact, then we get detailed analysis of the law over the page. the law being the first part of the overall detailed analysis, I think. I don't need to take any time on what's said about the law. I don't think anyone says that any of the law that's set out there is wrong. It makes the point about, albeit only in a footnote, about member of the local community, which I've touched on. It makes the point that a decision that's vitiated by bias is a nullity. So there can be no suggestion here that the Court of Appeal was in any way inhibited in dealing properly with the allegation of bias by any concern that finding bias would cause practical problems. And then the Court goes on to the question of linkage, sets out the passage from Ebner, which is alluded to in the Caristeas case that we looked at earlier, about needing to identify the logical connection. And then over the page, we get the section detailed analysis facts. There's a summary in that paragraph 73 of essentially the points that were made before the Court of Appeal and are repeated now. And again at 74, there is reference to deciding whether singly or in combination these points give rise to the perception of bias or the breach of any constitutional right, although that's a separate point. It would be necessary to consider whether, if not individually supportive of bias challenge 75, they can cumulatively or in any combination be sufficient to satisfy the test for apparent bias. So, in my respect, the submission, the Court of Appeal plainly gets the right test and plainly has well in mind that the question of what the reasonable observer would think must be based upon all of the relevant circumstances. And then 77 sets out, or refers to, rather, the Court of Appeal's findings in Pandey and Virgil. It is contended, says the Justice halfway through that paragraph, by the first and second named appellants that the findings of that court and its conclusions of apparent bias in that case are also relevant to the issue of apparent bias against them by the Chief Magistrate in the instant matter. That contention must therefore be examined. And this is, of course, picking up on the point about linkage. Clearly, it can't be denied that in Pandey and Virgil there were grounds for concern about apparent bias. Indeed, that was the finding of the Court of Appeal. But the question is, what about these appellants in this case? There's then quite a long section where the Pandey and Virgil case is looked at, and there are some quite long passages set out from Pandey and Virgil, as your Lordships can see over the succeeding pages. And at the top of page 186, at the end of after a lengthy quotation from the decision of then Justice of Appeal Archie in Pandey, we see at 83, on his own admission, therefore, it is not in dispute that the then Attorney General had taken active steps to assist the Chief Magistrate in selling his property, or that he intervened in relation to his failure to testify against the then Chief Justice. This was revealed in the statements and press releases from the parties, which were considered by the Court of Appeal. It is significant that his allegedly being beholden to the then AG was apparent since the decision in Pandey and Virgil. And then the Court of Appeal confronts straight on this question of perception of being beholden to the then Attorney General, and says, in this case, however, the informed observer would not be able to discern a similar obvious link between the instant appellants and the then AG. This would be necessary, as they allege that it is the CM's being beholden to the then AG that puts them at risk of the decision by him being tainted by apparent bias. It must be considered whether, viewed objectively, those matters discussed in Pandey and Virgil were sufficient either by themselves or in combination with other matters to justify the instant allegations of apparent bias and the link between them, if any, and the instant matter. There is then reference to the court below and what it was that was put before the court below. And then the court turns to its own conclusions at 87, linkage in Pandey and Virgil is the heading there. It was contended that the Chief Magistrate was beholden to the Attorney General and the government, and the likelihood was that there would be at least a subconscious desire to do what he perceived might please the current political directorate, essentially my learned friend's point. Even if, for the sake of argument, this is all accepted, the link between any such desire to please and the outcome of the committal proceedings in relation to these appellants has not been demonstrated. And then the court sets out how the link was demonstrated in Pandey. Conversations concerning the fact the Chief Magistrate was about to deliver judgment in a matter of that appellant, intervention by the Attorney General to exonerate him from further investigation. After an investigation of sorts, overcoming the refusal of another of the companies to repurchase the land, all the same points that my learned friend refers to, and intervention in relation, over the page, in relation to the decisions of the Chief Magistrate concerning testifying in further proceedings in another matter.
I don't know how much more he could do to make himself indebted to the Attorney General.
Well, my lord, I can't. I'm not sure I can say much in response to that issue. The facts speak for themselves. But the question, which the Court of Appeal rightly focused on, is does that go far enough to justify apparent bias in relation to these appellants? In Pandey and Virgil, they say at 88, there were admitted conversations in which the appellant's matter featured, although their content varied depending on whose version was accepted. And in that matter, it was found that the reasonable observer would have known the appellant and then AG were political adversaries and would have considered the timing of the exoneration, the repurchase of his land, and the judgment he delivered in that matter. Then there is reference to the significance of not raising these matters in previous judicial review proceedings. This picks up something that I was being asked about by Lord Sales a few minutes ago, I think.
Yes, but I'm looking at these paragraphs. It rather reinforces the point I would put to you, that I was seeking to put to you before. So they say, in 89, although natural justice was raised in the first judicial review proceedings, so those are the ones that we were talking about, not pursued at the Court of Appeal, the logical possibility is that the Court of Appeal's findings on apparent bias in Pandey and Virgin then were not sufficiently linked to the appellant's case, and that they continue not to be sufficient now. So no linkage at all. But then they say the most favourable inference is that it was insufficient then for a bias challenge, but coupled with matters that were progressively revealed later on, became sufficient in combination with these so as to crystallise a sustainable challenge on the ground of apparent bias by April 2008. And then at 91, they say, for the purpose of this, or for the purpose of analysis, i.e. what the Court of Appeal is now going to do, we are prepared to assume that the most favourable interpretation of the failure to challenge on the jurisdiction issue. So that seems to be the court saying that the starting point is there was insufficient to even raise the matter in, was it July 2007, the first judicial review, but some things may have happened since then. That tends to bring out that the judge was taking the starting point as, well, we all have to begin from the point that there isn't sufficient link with the findings that were made in Pandey, and then you're just looking to see whether, if you've got those findings, but then you add some other things in, that makes it sufficient for an apparent bias challenge. And again, my question to you is that really the appropriate way of looking at it, where the matter simply hadn't been raised in the first judicial review proceedings? Was it appropriate for the court in this case to treat it as a baseline that there was no good case of apparent bias in July 2007?
Well, I'm not sure I'd accept the premise of that. The reason in my submission why one can see from the judgment why the Court of Appeal is talking about the earlier case is dealing with the argument, the idea that the absence of raising the matter in the previous proceedings indicates that there's nothing in this point about bias, because the heading of that is significance, if any, of not raising these matters in the previous judicial review proceedings. So the suggestion is, well, maybe there's a point against this bias challenge that, well, this wasn't said at the time, so therefore there's nothing in it. And I mean, it's true that the court doesn't say what I suppose logically it might have said, which is, well, it doesn't really matter either way. Who knows why they didn't raise it but that doesn't affect our decision now. We have to decide on the basis of all of the facts as they currently stand. But that, in substance, in my submission, is what they do say. They say at 90 the most favourable inference is that it was insufficient then for a bias challenge. In other words, the answer to the point, well, they didn't bring the bias challenge then because there was nothing in it, and that's a sort of admission with which these appellants should be fixed, even though they weren't actually the parties to that case. The answer to that is, well, perhaps there wasn't enough then, but there is more stuff now. I mean, I take the point, but it might have been more sensible to say another answer is that, for whatever reason, counsel in that case didn't take the point, but so what? But then the court goes on at 91. For the purposes of analysis, I think probably the way to read that sentence actually is, for the purpose of analysis, we're prepared to assume that most favourable interpretation, the one that's just been referred to. If so, and this is the critical point in my submission, if so, the issue which must be confronted is whether that material, properly analysed, establishes a real possibility of bias on the part of the Chief Magistrate in relation to these appellants in coming to his decisions on the application for his recusal and his decision to commit them in the proceedings before him. So, my Lord, in my submission, the board might say, I suppose, that, and it may be from some indications, it may be that some of your lordships are inclined, as presently advised, so to say, that the Court of Appeal got the overall answer wrong. But in my view, that's a different point from whether there was an error in the reasoning process, which involved thinking that because the judicial review claimants in the earlier action hadn't raised it, the baseline is that there was nothing then, and it all depended on the further material. That isn't the reasoning of the Court of Appeal, fairly read in my submission. Fairly looked at, the Court of Appeal squarely accepted that it had to look at all of the material before it and determine, in the light of that, whether the judge had been entitled, in the light of the same material, to come to the conclusion to which he came. And the Court of Appeal answered that question in the affirmative. In fact, itself looking at the material in more detail than the judge had, or at any rate setting out its reasoning in more detail than the judge had, came to its own conclusion. And, my Lord, the question really in my submission is whether that conclusion is one that one can stigmatise as having been one that's seriously wrong in principle.
Well, I wonder whether the right way to read the paragraphs through to 95 is that the court here is saying, as at the time of the Panday judgment in the Court of Appeal, there was the possibility of an allegation. You see in paragraph 94, allegation is given emphasis,
yes,
that he could be perceived to be beholden. But they contrast that in paragraph 95 as to whether matters could have given rise to a perception of being beholden. In other words, drawing a distinction between being able to make an allegation and being able to make good a case that there is a perception of apparent bias. And what they, I mean, I'll have to reread this again, but what the court seems to be saying is there isn't enough at the time of the Panday judgment to give rise to a perception of bias. And so what we're looking at, in particular paragraph 93, are whether taking the baseline of able to make an allegation but insufficient to make good a case on perception, as at July 2007, whether adding 93A and B changes the picture. And at paragraph 95, they say, no, it doesn't. So the baseline is, if you just start with Panday and what had happened in the July 2007 judicial review, no apparent bias. Query, has the addition of points A and B in paragraph 93 changed that? No, it doesn't sufficiently change the underlying picture where the baseline is no apparent bias.
Well, it's important to be sure, I think, I would submit as to what the Court of Appeal is referring to when they talk about bias. Are they talking about bias in relation to the issue that was the issues that were between the parties in the Panday case, or are they talking about bias in relation to the issues in the present case? Plainly, in relation to the Panday case, the Court of Appeal can't be saying there was no grounds there were no grounds for fearing bias in relation to the issues that were before the court in Panday, because the Court of Appeal decided that there were grounds for bias. that their analysis in this passage and on this page is directed towards the question in relation to these appellants and what the...
I find it very hard to see how they can possibly say in paragraph 94 that the Mustill Tribunal findings added nothing to what was already a matter of public record. It's pretty fundamental additional facts that they mention there, that he had received and deposited the cheque. Plus, there were substantial criticisms of it made by the Mustill Tribunal in its report, which might lead the reasonable observer to think that he was all the more in need now of assistance if he could get it if he had an ally in the form of the Attorney General.
Well, the Court of Appeal in Panday had found, on the basis of the facts as it then understood them to be, that there was a case of apparent bias was made out.
Well, I agree. Once you've got apparent bias, in a sense, you don't need anything.
That may be essentially what the Court of Appeal means. But one has to credit the Court of Appeal with some degree of good sense about this. It would be surprising if they meant that really the fact that the Chief Magistrate had deposited the cheque wasn't significant. I mean, that's plainly from a general point of view, looking at his conduct and whether his conduct is suboptimal, as it were. Of course, it makes a big difference. But they're looking at it in the particular context of these appellants and this case.
Sure, but Lord Leggett is saying in 93 to 95, there's a serious downplaying of the significance of those new facts. And that is a point that I had observed similarly at page 171 in the summary, in paragraph 61 2b. They treat this evidence as tantamount to further and better particulars. Now, that does seem to me to be a serious understatement of what was revealed in the Mustill inquiry as to the nature of the behaviour by the Chief Magistrate and as to the degree to which he might be beholden to the Attorney General for getting him out of a very serious hole that he dug for himself.
Well, I think I can only answer that, I think, by going back to my point that that once it's been found that in relation to the issues in the Panday case there was apparent bias, then the fact that the position looks even bleaker from the Chief Magistrate's point of view once you discover what you discover in the Mustill Tribunal doesn't make much difference in that sense, because I mean these things are binary. I mean the answer is either guilty or not guilty in relation to Panday on the issue of apparent bias. And what my submission, what the Court of Appeal must have meant by tantamount to further and better particulars is, well, guilt had already been established. And so the fact that you could say actually things looked even worse from his point of view doesn't alter that, but that still doesn't.
Surely it's the other way around. That the underlying reasoning here is guilt in the present proceedings had not been established, and there was nothing in the additional matters in terms of the evidence given by the Chief Magistrate to the Mustill inquiry that changed it from a picture where guilt, if that's the right word, had not been established into one where it had been established.
Well, that's in relation to that's in relation to these appellants in this case. That's the distinction they're drawing. I agree. What I was saying was in relation to one has to bear in mind that in my submission they're dealing with submissions that say look at all of the things that have happened since the Court of Appeal's decision in Panday, and the way I'd invite the board to read the judgment is that the Court of Appeal is correctly directing itself. Well, the issue for us is not whether this all makes a difference as regards the outcome in the Panday matter, because we already know in the Panday matter that there was a finding of apparent bias, and the fact that there are some the fact that having reached that, not only did the defendants in the Panday matter reach the threshold of apparent bias, but in fact we now know if only they'd had the evidence they would have not only reached it but surpassed it by some considerable margin because of other matters, doesn't by itself tell you anything about whether there is sufficient material in the present case.
Yes, well, I see that. I mean, they're taking at 95 as a given that the Chief Magistrate was beholden to the Attorney General. And then they go on to consider the linkage in the following paragraphs, and they ask the question, was he so generally beholden and indebted to the Attorney General as to commit the instant appellants regardless of the merits? What he's saying is, yes, he's been beholden, but you haven't established that that has tarnished his decision-making a year later. That seems to be what they're saying.
Yes.
And they're actually putting the wrong question, aren't they, at the end of that paragraph in 96, saying, was he so generally beholden as to commit the instant appellants, whatever the merits? It doesn't have to be that high. The question is, was he so generally beholden as to be, as a reasonable person might think, that he might be affected in his decision by that fact?
Well, Your Lordship's of course right that the test is as Your Lordship just expressed it, and not was he so beholden enough to commit the instant appellants, whatever the merits of the case against him. I accept that, but this is in my submission. It's pretty plain looking at the judgment as a whole. They're not mistaken as to the overall test. They understand.
I mean, if the Attorney General had nothing to do with the prosecution of these appellants, that might be a legitimate view, but he did have something to do with it, didn't he?
Well, that's the point that the Court of Appeal tackle directly in the passages that we get to very shortly. But just before we do it, I want to make clear my submission is there isn't by virtue of the way in which the Court of Appeal dealt with the Panday matter and the significance of it, and this reference to further and best particulars and so on. There isn't an error of law there in my submission. I mean, it may be that one could say things might have been more felicitously expressed, but when one looks at the thing as a whole, it's pretty plain in my submission. The Court of Appeal rightly approached the question on the basis of whether, given everything that was before them, whether it had come from Panday, whether it had come from the Musteel Tribunal subsequently, whether in those circumstances the test upon which they correctly directed themselves was met, and whether the judge had been entitled to conclude that it was met. And we see this following it on at 97.
And just before you go there,
yes.
Mr. Rowe, I suppose what might be said is that this section and elsewhere, this is not necessarily a criticism. It is a very lawyerly approach. Whereas I think there is authority that the reasonable observer, fair-minded observer, is not a lawyer, is a member of the public. And I'm wondering whether you would accept the approach laid down in a Scottish case called Miller against Dixon, where Lord Bingham, I think, said what one does is look at all of the relevant circumstances at the relevant time, namely January 2008 here, and ask, would the hypothetical observer consider that there was a legitimate doubt as to whether the judge was impartial or not. In other words, what I'm suggesting is perhaps this is a little overly complicated, and the task is really to compile the relevant circumstances in January 8 and apply the test to them.
Well, I don't think I can dissent from Your Lordship's statement of the law. Plainly, that's right. I accept that the reasonable observer is not a lawyer. Equally, the reasonable observer is. I mean, one can find dicta saying various things about the reasonable observer. It's one of these curiosities of the common law. It's a person to whom attributes seem to be added case by case as one goes along. But plainly, the reasonable observer, though not a lawyer, is somebody who nevertheless understands a certain amount about how things work, and that's presumably the reason why it's right to say, as the Supreme Court of Canada did in the case we looked at earlier, the RDS case, that one requires cogent evidence to conclude that a judge may have departed from the judicial oath, which itself, as a proposition, suggests that one shouldn't one shouldn't place too much reliance on the notion of the reasonable observer as a mere entirely unfamiliar with the law, a member of the public, because it may not be that every member of the public knows about the judicial oath, but for the purposes of this, it's deemed to be. But so I accept the general proposition.
It is possible to overcomplicate.
Yes, I would accept that. What I'm not sure I could concede is that this judgment is guilty of that error. I mean, one makes of it what one can, but in my submission, it's undoubtedly a pretty thorough exercise in going through the facts quite carefully. And as I think we are agreed between the parties, the question is whether the court went seriously wrong in principle in the decision that it came to.
Yes, thank you.
So, my Lord, just really concluding with what the Court of Appeal decide on this aspect of matters, they say at 97 that the appellant's contention was that the decisions of the Chief Magistrate, let's keep an eye on the time, rejecting the recusal applications and committing the Piarco defendants might well have been seen as decisions that they would please the Attorney General of the government and the current political directorate more widely. The difficulty with this submission is it involves an extraordinary degree of speculation to supply the missing link between the outcome in this case and the wishes of the then AG. While that link was established in Pandey and Virgil, it is missing in this case. And that 98, even assuming that the Chief Magistrate were to have been perceived to be beholden or indebted to the then AG for the reasons examined previously, so in other words, on that very footing, the translation of that indebtedness into an outcome adverse to these appellants, emphasis given by the court, these appellants, has not been made out.
Again, is that not the mistake? He's applying a test of a link between the being beholden and the outcome. It's the same mistake that Lord Leggett was pointing out to you in relation to paragraph 96.
If one takes from that paragraph, and possibly from the earlier paragraph, if one takes it from that paragraph that the Court of Appeal thought that you had to prove that apparent bias, causation, essentially, then I agree. That would be an error. But actually, if you look at the thing as a whole, it's pretty clear that the Court of Appeal directs itself correctly, that what matters is perception of apparent bias. The language is a bit loose here in my submission.
But he's highlighted outcome as well as these appellants. So it does seem a strange approach.
Well, I can't deny that way of putting it, were that to be the operative aspect of the decision, would be an error. But in my submission, one looks at the whole of it, and this is in the context. This is in the context of considering whether the specific point. It comes back to the linkage point. This is in the context of whether these appellants can take the point that, well, look at the degree to which we say there's a perception, a reasonable perception, that the Chief Magistrate is beholden to the Attorney General.
Perhaps we ought to be looking exactly what it was that these appellants were charged with.
I
understood it to be something to do with, if not the Prime Minister, then at least the Minister of Finance being involved in corruption over the airport.
Yes, I'm not sure I've got the reference at my fingertips to the page in the indictment, no doubt, in the informations. No doubt my own friend will take you to it in due course. But I agree that the charge, as I understand it, was a charge of seeking to suborn. I think it's in my own friend's case, the amended charge was seeking to suborn the Minister of Finance corruptly by making payments.
SFI, Paris 22.
I'm very grateful, my friend.
And then para 14, 2737. It's all of it.
Yeah.
2737, 2739.
I suspect your lordships might have heard my own friend's attempt at sotto voce.
Paragraph 22, 2739. Yes.
Yeah. No, that's right. So in terms of the specific reference to the Minister of Finance, it's 22.3, isn't it? It's the amended charge of corruptly giving a financial advantage to Mr. Kwei Tung, former Minister of Finance.
Accepting that the Attorney General was not himself biased but merely overzealous, you don't have to be a close student of human nature to think that he might be a little disappointed if the next batch of defendants being prosecuted by the Special Anti-Corruption Commission he'd set up to investigate members of the previous government were all let out and no case to answer, by the magistrate.
Well, my Lord, can we look at what the Court of Appeal thought about essentially that proposition? Paragraph 101. These are matters that cannot by themselves require attribution to the then Chief Magistrate or the then Attorney General of an interest in procuring an outcome by means other than that recognised by law. The notional, fair-minded and informed observer would readily accept that while the process necessarily involves a prosecution by someone, and in this case that prosecution was under the aegis of the then AG, the actions of the CM cannot be assumed to be based on a desire to please the then AG. And then they refer back to some
slipping into actual bias rather than apparent bias, is it not?
Well, I can see why Your Lordship says that, but looking at the sentence as a whole, that's still a reference to what the notional, fair-minded and informed observer would think, rather than the court saying it's got to find whether there was actually bias or not. And then there are references back to the various things that have been referred to, which are all the things that my learned friend has talked about in the course of his submissions. And they say 1, 2, 3, 4, and 5, all matters that were the functions of the office of the AG and without more could not of themselves be considered legitimate. Neither can 1, overzealousness in the pronouncements of the then AG of itself be presumed to infect the separate decision-making capability of the actual decision-maker, the CM. And then 102, while such an observer might contemplate that a possibility could exist that such an outcome generated by the CM might be based on a desire to please the then AG, that is not the test. A real possibility is what is required. The analysis of whether a real possibility exists must involve the notional observer applying his mind to the facts and circumstances which could give rise to such a real possibility. It is not enough to speculate that it might be so or could be so. The extent, next paragraph, to which the CM would have cause to be grateful to the AG in this case would not lead the notional, fair-minded observer to conclude that the level of gratitude or being beholden would translate to a desire to please the then AG at the expense of his professional reputation.
Well, one might ask, what professional reputation by this stage?
Well, I confess I thought Your Lordship was about to say that when I read the words professional reputation. But one, of course, is looking at this from the point of view of the Chief Magistrate clearly thought he had a professional reputation. We can see that's in many places in the evidence. And the question is, would the reasonable observer think that this level of gratitude or being beholden would translate on the part of the Chief Magistrate to a desire to please the Attorney General?
If he had any chance of saving his position, the Attorney General was about the only one who could come to his rescue again.
Well, except that by that point, things had, he was where he was at that stage. The only thing the thing that was.
I agree. I suppose he was already under investigation by the judicial.
Yeah, the thing that
he staved off suspension through judicial review.
The thing which imperiled his ability to carry on as Chief Magistrate was the Judicial and Legal Services Commission, and one certainly can't, in my submission, say, well, because a judge is under investigation by that body, therefore he or she is disqualified generally from acting. But focusing on the critical point here, that we see the Court of Appeal dealing squarely with this issue. They say, in fact, the matters that related to the creation of the perception of being beholden all arose in the context of the Pandey trial and the then attempted impeachment of the then CJ, as demonstrated by a summary of events set out in Pandey and Virgil in the Mustle inquiry, etc., etc. However, end of that sentence, a link to the instant proceedings is not at all clear. The appellants Smith and Gomes, 104, have not demonstrated that there is any particular reason why a reasonable observer would perceive that in relation to them, the CM, even if beholden to the then AG, would be predisposed to determine the matter against them or even their co-accused. The reasonable observer would therefore struggle to discern such a link in this case. In fact, such a reasonable well-informed observer would dismiss such a link to the instant appellants in these circumstances as speculated. And in my respectful submission, my Lord, that shows the Court of Appeal dealing squarely with the correct test. I appreciate that some of the language might be criticised at an earlier stage as having been a bit wayward in terms of talking in references to outcomes and so on, but here they talk about predisposition, which is precisely the point. Would the reasonable observer have thought that there was a predisposition to determine the matter against these accused? And the Court of Appeal, in my submission, well placed to determine that issue, and my learned friend confirmed there's no suggestion whatsoever that the Court of Appeal themselves are guilty of any apparent, still less actual bias in dealing with this question. They, with all of their knowledge of the local scene, which is important for the reasons I've mentioned earlier in my submission, come up with the conclusion that although there might be a possibility, there isn't a real possibility. So it's not as if the Court of Appeal was dismissing this whole idea contemptuously and without proper analysis. They confronted the possibility, but said that ultimately this wouldn't be a real possibility. And they go on subsequently then to deal with the need to establish a link, again recapitulating what perhaps has already been said.
Do they discuss at any stage his vote fast in the actual proceedings? Do they comment on that?
140.
Or we look much later, do they? I don't want to take you out of order.
No, not at all. I'm really just since you raised the point. Yes, they deal with that matter in which charges were substituted, whether reflective of bias.
That's sort of 204.
That's right, 204. And they say, while this decision, they talk about the decision to adopt the amended additional charges, they say it still requires scrutiny insofar as it may be contended that this is a link in the chain of bias culminating in the actual decision in January 2008, which is subject to this review. They say this contention cannot withstand even the most basic scrutiny. It has been noted that the CM had already complained about alleged interference by the CJ in the Pandey matter since May 2006. He gave his ruling on the substituted additional charges in the instant matter almost a year later in July 2007. So they're linking it there, particularly to the follow the guidance of Mr. Jenkins QC point. Given the lack of significance that would be ascribed by the notional well-informed observer to the alleged direction by the then CJ, it would not be possible to complain about the manner in which charges were substituted on the 9th of July. If even not subject to a time bar as reflective of bias.
Well, the 140 to 145 focuses on the temporal relationship between the allegation of interference by the Chief Justice and the ruling on the substituted charges, and goes on to say that he certainly had jurisdiction to do so, but does it anywhere address the absence of an explanation for the volte-face?
No, I agree, it doesn't.
Yeah.
It doesn't. And all I think I can say about that is I stand by my point that the appellants do rather assume what they seek to prove in this context. I mean, they say the judge did this thing which wasn't what they wanted him to do, and which perhaps is unusual. Therefore, that can be evidence in support of our bias challenge. Well, in my submission, that's a classic instance of begging the question in the proper sense. So it doesn't take these further forward. But I agree. The Court of Appeal don't deal with it. Deal with it.
No, but if a judge does something that would call for an explanation, whether it's saying you're not good to the prosecution, you're not going to be allowed to bring forward these charges, and then saying, I'll do it. Now, I don't want to push this too far, obviously, because we're going to get given materials as to that volte-face. Or later on, given the whole background history, when an application for recusal comes in, dismissing it as vexatious, then the fair-minded and independent observer might say, what's going on here? It might call for an explanation. That doesn't necessarily mean that one is assuming there is bias, but it is still a factor that goes into all the circumstances when you're assessing whether or not there is an appearance of bias.
Well, I would agree with that to the extent that one could say this was, as it were, a departure from what ought to have happened, and that's why it's important to look at the detail of it, and we'll put that before the board in due course as requested. But the extent to which there's anything in that point does rather depend upon the extent to which it's an obviously aberrant decision. I mean, if the judge decides a case in one way when you might have thought the evidence, by and large, pointed the other way, you don't immediately jump to the conclusion that the judge must be biased. You say, well, the judge took a different view of things. I mean, it depends how inexplicable it is. But in present circumstances, there's no more. Judged on its own, there is no more reason to think that is the result of bias than there is to think that is the result of the judge, the magistrate, having said at one stage, well, I don't want you to start bogging down this case with amendments, and then subsequently, when he comes to sit down and consider his judgment, think, well, actually, yes, exercising my jurisdiction to commit for whatever I think has been revealed on the evidence, on reflection, there is something in those points.
Yes, I mean, a judge can reach a wrong decision and even an unjustifiable decision without being able to infer from that bias. I fully accept that. All I'm suggesting is that it is part of the factual circumstances.
It is.
It may take its colour from other circumstances.
It is, although it's also part of the factual circumstances that there's no suggestion in this case that what the judge did was substantively wrong. There isn't a challenge saying he wasn't entitled to commit, or his volte-face was itself unlawful, and that's also relevant.
Sorry, I thought there had been a challenge to that. Was that not the July?
There'd been an earlier challenge in relation to the rejection of the no case submission.
Yes,
right. Well,
which is at an earlier stage. I don't think there had been anything. I don't think I'm right. Maybe if I'm mistaken, I'll withdraw the point. But
well, this is where we're slightly hampered by not having a very good chronology. I thought this was well, maybe I'm wrong, but this is the decision to commit for trial is 9th of July 2007. I thought that the judicial review that was being talked about in the Court of Appeal was July 2007. And was a challenge to that decision. That's the one where the Court of Appeal in this case said, well, they didn't allege appearance of bias in that case.
No, well, there are two separate decisions. If you go to the chronology,
July 2007.
Yeah.
2772.
2772, bottom of the page. 9th of July, the Chief Magistrate discharges the Piarco 1 defendants on all 21 of the original charges, rules there is a case to answer in respect to the 7 amended charges and the 3 new charges identified in the prosecution's notice of 11-10-06.
Yep.
13-707 calls on the appellants to answer the 10 amended and new charges. 19-707, on application by 2 of the corporate defendants, the High Court grants leave for judicial review.
Yep.
That's determined on the 30th of July. Skipping to the bottom of the page, Court of Appeal reverses that order, 19th of October. Then we have, on the right-hand page, or 2774, if you're following electronically, 7108, Chief Magistrate dismisses the applications for recusal and a referral to the High Court and commits the appellants and the other Piarco 1 defendants to stand trial.
Right, so what's happened to the judicial review for which the Court of Appeal...
The judicial review, the Court of Appeal reversed the order, reversed the order granting leave. So right. Probably the answer is we're both right in the sense that these appellants didn't challenge, I think I'm right in saying, any aspect of the substantive decision of the Chief Magistrate.
The 2 corporate defendants did.
2 corporate defendants challenged the decision.
Leave to have a judicial review was overturned by the Court of Appeal.
Yes.
Yes.
And your lordships are, of course, with respect, quite right to say that you really ought to have that. So we'll make sure that you have that so as to get the full picture. But that's obviously important as part of the context.
But at all events, that does suggest that there has been judicial scrutiny of what's been called the volte-face.
Yes,
we just don't have.
I agree. We don't have that, and we ought to. So that's
Okay.
mea culpa, or on all sides, I expect. Anyway, that ought to be provided, and it will be provided. But my point for present purposes is that it doesn't, by itself, it's a bootstraps argument essentially to say, well, because he did that, therefore there's bias, because maybe so, maybe not. But your lordships are right to say that wasn't directly addressed by the Court of Appeal. Now, my lord, I think I was just going through the way in which the Court of Appeal dealt with it. I think more or less dealt with how they got to the point about being beholden to the Chief Magistrate. They then touch on other aspects, principally. Bottom of page 193, para 105, they talk about the argument that it was an accumulation of matters progressively and subsequently disclosed that led to the application for recusal. They talk about the institution of the disciplinary proceedings on page 194, para 106, confirmation of the disciplinary charges. They then talk about alleged unfitness as a constitutional issue. And they say on the face of it, but this is, although they head it that way, they are still talking, I think, about, Justice Rajkumar is still talking to some extent about the common law test, 110. Even the basis of an allegation that his credibility as a judicial officer has been undermined requires something more, a basis for an allegation of apparent bias in relation to the instant committal proceedings or a finding of unfitness, even a preliminary one, by the appropriate constitutionally constituted body entrusted with the determination of such an issue. No such finding was ever made. On the face of it, allegations or potential charges arising from a failure to testify in an unrelated matter cannot by themselves satisfy the test for apparent bias. And then this is picked up over the page, going back to the common law aspect, the bias aspect, the contention, 112, the contention that the Chief Magistrate was biased as he would wish to please the powers that be cannot be sustained in relation to the JLSC, as A, it is a constitutionally independent body, and B, it is difficult to see how it could have any interest in the committal of the appellant such that their committal could ingratiate the Chief Magistrate to it, which is a good point.
I don't think there's been much pushing against that conclusion.
No. I mean, it's plainly right, and that point is sort of essentially elaborated on to some extent in the succeeding paragraphs. That matter has no obvious connection with the instant appellants or the PI involving their co-accused. So, my lord, that probably I think deals with everything I need to deal with in the judgment of the Court of Appeal on the issue of bias, and I do respectfully submit, for the reasons I've given, that one does need to look at this in terms of whether the Court of Appeal went seriously wrong in principle, rather than simply whether one disagrees with the outcome of the decision, and be judged by that notion, judged by that test, bearing in mind the care with which they addressed matters, albeit I accept one can make some criticisms about aspects of their reasoning or aspects of their expression, certainly. That is a decision which is supportable and ought to be upheld in relation to the question of bias. Your lordships were taken, I should just say, in closing on the question of the right test, and this is possibly slightly out of turn in a postscript, but your lordships were referred to the I think it was called the Al Hassan case, that my learned friend talked about in this context as an example of the House of Lords simply departing from the decisions of the courts below. It's fair to record, just so that I'm not guilty of neglecting to deal with authority that might be said to be contrary to my position. It's fair to record that my friend is right, that in that case it wasn't addressed by the House of Lords explicitly in terms of the test that I'm advocating. Was there a significant error of principle in the way in which the court below dealt with matters? I think that was one that my own friend either sought to hand in and was rebuffed, or didn't decide to hand in because of an earlier rebuttal. I can't remember.
We have Al Hassan now.
You've probably got a copy by one of the other means. Just really for information to take your lordships to the relevant, what seemed to me to be the relevant passage, and that this is at paragraph 37 in the judgment, in the speech, I should say, of Lord Brown, with whom I think the other members of the committee agreed.
That's page 15 in the supplementary.
Page 15 of the supplementary, that's right, supplementary document. I return, therefore, against the background of the relevant case law to the critical question, how would a fair-minded observer regard these appellants' adjudications? Would you think it a real possibility that Mr. Coppell, having been present when the squat search order was confirmed by the governor, would be predisposed thereafter to find it lawful? Would he, therefore, in the language of the Strasbourg court, feel doubt, however slight, in its justification about Mr. Coppell's impartiality, etc.? And then the submission of Mr. Sales, brackets as he then was, for the Respondent Secretary of State is set out. No, line not crossed. And it's fair to say that that submission seems to be put principally on the basis that, well, just looking at the merits of the case, the Court of Appeal were right. But we see at the end, between letters E and F, finally, Mr. Sales reminds us both courts below, finally, Mr. Sales reminds us both courts below, including in particular a Court of Appeal presided over by Lord Chief Justice Wolfe, with all his expertise and experience in this field of law, found nothing intrinsically unfair in Mr. Coppell adjudicating on these charges. In determining the objective impression given by these adjudications, he submits the House should give due weight to these earlier findings. For my part, I've not found this an easy case. There was undoubted force in Mr. Sales's arguments, and there could be no question but that Mr. Coppell himself undertook these adjudications in the best of good faith, etc. On balance, however, I have come to the conclusion that the bias argument is here made good.
Yeah. I mean, speaking for myself, I am not sure one gets a huge amount of assistance out of this particular authority for what we have to grapple with. So at paragraph 27, Lord Brown says that in the courts below, it appears that the major thrust of the fairness challenge related less to Mr. Coppell's own prior involvement in the actual decision-making process than to his background knowledge and so on.
Yes, so it's been argued a bit differently in the court below.
The argument had gone off in a different direction in the House of Lords.
Yes.
I think.
Yes. Well, that may well provide. I mean, it's clearly not a matter that's considered in detail there. That's to say, the test to be applied isn't considered in detail there. But plainly, the fact that the argument had gone off on a bit of a different track in the House compared to in the Court of Appeal might be a reason for the House of Lords being more inclined to take its own view rather than to approach it on the basis of whether the court below was entitled to find what it found. My submission for the present case, and generally as a matter of principle, I submit with particular force in a case where it's the board dealing with, rather than the Supreme Court as it now is, when it's the board dealing with a case from a jurisdiction that has its peculiar, in the technical sense of the term, traditions, is that the test really should be, well, has something seriously gone wrong in principle, rather than just do we agree with the decision that was taken. Unless, of course, one can find, I concede, of course, if one finds an error of law in the which is really a way of putting the same point, if one finds an error of law in the way that the question was asked, then it may in those circumstances be appropriate for this board to form its own view. But in my submission, that's not the case here, however much one might find aspects of the Court of Appeal's way of putting things which might have been improved upon. So, my Lord, that's, I think, all I can probably usefully say, unless there are any further particular points that your Lordships think I ought to deal with on the bias point. Briefly, because I'm conscious that my own friend will want to say something. May I just check, in fact, whether I've lost track, I'm a confessor of the time and the timetable, whether I'm still... I think I'm all right. I've got until...
You have 15 minutes if you need them.
I'm grateful. Well, I won't take that as an invitation to think of 15 minutes worth of things to say if I don't have them, but I'm grateful for that, my Lord. That, I think lets me deal then with the constitutional question, the constitutional claim. And my Lord, I can take that fairly shortly, because my submission about that is that really there isn't any room in the present case for a separate constitutional claim. This is an instance in my submission, of that species of reasoning where recourse is had to fundamental principles entrenched in a constitution or in other jurisdictions such as the UK in the Human Rights Act, where actually the common law already supplies the necessary material, so one doesn't need to have such recourse. And I say that because if my learned friend is right in his contentions about apparent bias, then the common law supplies the answer to that. Well, the judge should have recused himself, and that's that. If he's wrong, and or rather, if the board finds that whatever its misgivings, the Court of Appeal was right in the decision that it reached, or was entitled to reach that decision, then there's no breach in my submission of the constitutional right to a fair trial before an impartial and independent tribunal. The application of the common law rules about bias have given the answer to that question. There has been a trial before such a tribunal. The proposition that seems to be being put is that there is a sort of residual category where even if one can't get home on the specific grounds of challenge, nevertheless, to put it in the terms that my learned friends put it in their case, the magistrate had been so discredited that he lacked the moral authority to give an impartial judgment as an independent judge abiding by the rule of law. My lord, my submission about that is that that's a pretty dangerous route to go down. It essentially involves coming up with a separate ground of review, the premise of which is that the judge has survived a challenge on the ground of bias, and necessarily the premise of which is also that the judge hasn't been removed by the necessary constitutional procedures, but which nevertheless, despite those premises, allows the court to say of a particular judge, well, really nothing that judge deals with should be allowed to stand. And it amounts, in my submission, effectively to inventing a route for removing a judge, which in my submission is simply not open to the court to do. And that's because, and we've set this out in our written case, that's because the Constitution itself sets out mechanics for what one does in the case of a judge whose moral authority, to use my learned friend's expression, that's not how the Constitution puts it, is in question. And of course, judicial independence being the vital quality that a properly arranged constitution has, it's important that one sticks by what the Constitution says rather than the courts devising an alternative means of undermining the position of a judge. My Lord, can I just take your Lordships briefly to our case where we set this out? It's 2835 in the electronic bundle, paragraph 16 onwards.
If one imagines that the bias claim was never made and the court was faced only with this constitutional, broader, extended claim, I find it very difficult to envisage how the court would proceed. Would one call for evidence, and then at the end of the day, what criteria does one use to establish this somewhat vague and all-encompassing possibility?
Yes, well, I respectfully adopt that observation. I mean, not only is it inconsistent with the Constitution's own mechanisms, but it's impractical in its operation, because it would require the court to devise a standard of
I can see it can't operate as an alternative to the apparent bias, but it is possible, I would have thought, for a judge, and I don't think we have to decide whether it happened here, but it may possibly have happened in this jurisdiction, that a judge gets into a position where he simply can't hear a case, because in any case where the judge sits, his position is such that a successful challenge could be made.
Yes, but that would have to be on the basis that in any case the judge, well,
because of the judge's conduct.
Yes.
That is, is just incapable of hearing any more cases.
Yes. Well,
certainly until allegations have been resolved.
Well, I suppose I should. I mean, despite the pretty robust way in which I put it in my case, I perhaps should say I'm not necessarily inviting the board to say never, because who knows what circumstances there might be. I suppose one can conceive of a situation where, for some reason, yes, it's apparent that a certain judge, by any reasonable standard, ought to be disqualified from sitting on any case, not just any case involving the state or involving some particular party, but any case. But for whatever reason, the constitutional mechanics haven't cranked into action to remove the judge. I suppose, conceivably, in such a case, there might be a residual jurisdiction under the Constitution for another judge. I mean, logically, it could be by constitutional motion to another High Court judge to say, well, that High Court judge can't sit for the following reasons.
Well, let's just imagine here, suppose there were an allegation that a High Court judge in this country had accepted a bribe and decided a case in favour of a party, and that allegation was being investigated. I don't see how that judge could possibly sit on any case until the allegation had been resolved.
Well, it would depend on the exact facts, wouldn't it, my lord? I mean, if it depends what you mean by an allegation. I mean,
I mean a serious allegation.
A serious allegation,
supported
yes.
by evidence,
yes.
which was being the subject of a formal investigation.
Yeah, that
might be resolved to acquit or to convict, but it would be untenable for the judge to sit and hear trials in any case. Well, that was outstanding, I would have thought. Well, even though he hadn't been removed by motion of both houses of Parliament or whatever.
Yeah, well, my lord, that would certainly be, on that hypothetical example, that would certainly be right. But one needs to be a bit careful about exactly what the circumstances were that would constitute something a serious allegation, because I mean, one does come across wild allegations being made from time to time by litigants, and it would be unfortunate if one could secure the removal of a judge from one's case on the basis of facts.
Though in this particular case, this particular judge admitted accepting what was tantamount to, well, obviously was a bribe before he returned it.
Well,
and that was what caused the judicial body to say he shouldn't be sitting at the moment. On one view, he shouldn't have been sitting on any case until that had been resolved.
My point, my lord, in relation, I mean, one sees entirely the force of that observation, my lord, but one sees, but in my submission, that on the facts of the present case, the question of apparent bias in relation to these appellants is, I submit, is one whose resolution determines the matter either way. In other words, if the board reverses the Court of Appeal and says that actually the Court of Appeal should have found that there was apparent bias here, then that's that. Conversely, in my submission, on the facts of this case, if the apparent bias challenge, if the failure of the apparent bias challenge in the Court of Appeal is upheld by the board, then there isn't room on the facts of this case for a separate jurisdiction that comes in to say, well, even though this was acceptable at common law, this is not acceptable under the terms of the Constitution. I mean, I take your Lordship's point that one, and this is why I say, I'm not inviting the board to say never, I can see there might be circumstances where, as I say, for whatever reason, there isn't a viable case of bias in relation to one particular case. Suppose the allegation is taking of a bribe or bias on some other basis in a particular instance. There's a judge has for some reason taken against some particular corporation, for example, take a semi-hypothetical example, then would it follow that the judge is disbarred from ever hearing any case or not? Well, it would depend on all the circumstances, and I wouldn't say there was. I'm not arguing there's never a situation where the court couldn't step in, particularly in a case in a jurisdiction with a written constitution that contains a guarantee of an impartial trial, which is a feature of the Constitution and therefore supreme. But none of this assists in the present case, in my submission, because everything can be satisfactorily dealt with under the rubric of the common law. Because if the bias challenge was rightly rejected by the Court of Appeal, that's on the basis that there was no ground for the reasonable observer to conclude that this judge would be biased against these appellants. And that being so, the fact that an allegation had been made of actually, what the way it's put, I think, my learned friend, it's the allegation of principally based on the Judicial and Legal Services Commission, albeit their wish to interdict had been thwarted by a judicial review application having been made. But that doesn't by itself, I think we touched on this earlier, amount to much in terms of the bias challenge, and in my submission it doesn't either in relation to the Constitution. So, I mean, just for completeness, the references are, I think, well, Your Lordship, I think Your Lordship has the point, but for completeness, it's 2837 in our case, and actually that's where we deal with it under the Constitution. But insofar as this is put as a claim under the common law, we deal with it from 2834 onwards, paragraph 15. And the particular provisions in the Constitution are set out on page 2836. Power to appoint persons to hold or act in the offices to which this section applies, which includes the Chief Magistrate, and to remove and exercise disciplinary control over persons holding or acting in such offices shall vest in the Judicial and Legal Service Commission. And a judge may be removed from office only for inability to perform the function of his office or for misbehaviour, and shall not be so removed except in accordance with the provisions of this section. And I notice, and I'm afraid this is something of a esprit d'escalier, but I noticed that we don't mention, I think, the case of Rees and Crane, but it's one that Your Lordships might recall, which is the case that says, I think, that you can't, I think it's referred to by the Court of Appeal, actually, but it's in this case, but it says that you can't exercise a power as the presiding judge of a court or a circuit or whatever. You can't exercise your power to decide what judges sit on which cases, to say Judge so-and-so shan't sit at all. If what you're really doing is suspending the judge, you can't, by that method, circumvent the constitutional provisions for having the judge suspended or removed by the Judicial and Legal Services Commission, or no doubt in the United Kingdom by address of both Houses of Parliament or similar. So, for completeness, I should mention that. But in my submission, that essentially in the present case, for the reasons I've given, the constitutional, or rather the lack of moral authority point doesn't work as a matter of common law, because it's all dealt with by the question of bias. And the same is the answer to the claim under the Constitution. There is essentially no scope for the Constitution to operate here. Either the appellants, either the bias challenge is right or it's wrong, or at least it's upheld or it's not upheld, and there's no more room for anything else. My Lord, I think, slightly ahead of time, I hope that concludes what I wanted to say, unless there are particular points that any of your Lordships feel I haven't dealt with and might be able to do now.
You are, Mr. Rowe, precisely on time. Thank you very much.
Thank you. Mr.
Fitzgerald.
Oh, right. My Lords, well, just on the approach I provided you with the case of Al Hassan, and there's also a case called Stubbs, which is where the board reversed the position of the Court of Appeal in Bahamas on the question of bias by way of predetermination. And I think it's paragraphs 34 and 35. Is Stubbs around? I think it has been sent to you. But you'll see there that they simply took the view that it was the approach taken by the Court of Appeal in that case was wrong. There hadn't been an earlier court because it was the Court of Appeal that was flawed by bias by way of predetermination. But can I just make my submissions in this way? This is about natural justice. It can't be a Wednesbury test. You can't say, when you're considering an issue of natural justice, it's unfair, but it's not so unfair that it's not within the band of reasonable things. It's either unfair or it isn't unfair. It's either bias or it isn't bias. If there has to be some limit on it, then I would submit that at the appellate level and at the tertiary level, it may be sufficient that the court simply says, is it plainly wrong? But this idea that you import some Wednesbury test, which is about the rationality of a substantive decision, into an issue of natural justice is contrary to the whole way in which natural justice has been developed, in which tertiary courts do often say the other two courts got it wrong. And they don't say they may have got it wrong, but they didn't get it so badly wrong that we're going to interfere. They just say they got it wrong because this is a value judgment which defines the standard of natural justice for all the inferior courts. So you can't sort of say, well, it's within the margin of appreciation. It's not, and it's not so badly unfair that we'll let it go, or it's not so badly biased that we'll let it go. Wednesbury's got absolutely nothing to do with this. And if you look at, I accept my Lord Sell's point about Al-Hassan, but really, in the end, Lord Brown just said, is this a case of bias? If you look at Stubbs at paragraphs 34 and 35, this board in the end said, is it a case of bias? But if we do need errors of law, I'm indebted to your lordships for having identified them. And I respectfully submit that the analysis that my lords put to my learned friend at paragraphs 96, where it was, as it were, the requirement was whether he would commit the instant appellants, whatever the merits of the case against them. That's not the test. Paragraph 97, again, that's not the test, obsessed with outcome. As my Lord Malcolm put, it's Lord Bingham made clear that where there's a legitimate doubt, you should recuse. Paragraph 98 again is the same. It's outcome oriented, and paragraph that's a paragraph 98 at page 191, and one can see to be perceived to be beholden or indebted to them for the reasons examined previously. The translation of it into an outcome adverse to it has not been made out. All there has to be is a risk of it. And as for the hair splitting about whether there may well be a possibility, but there's not a real possibility at 102, that's hardly consistent with the approach of Lord Bingham, that if there is a legitimate doubt, you resolve it in favour of recusal. So I do respectfully submit that if it is necessary to identify an error of law, which I question, then there is an error of law in the high test, outcome-oriented, essentially real bias rather than apparent or risk of bias, that is being applied by the court at a crucial passage, paragraphs 96, 97, 98, and 101 and 102. So, well, that's my respectful submission on that. As to the Court of Appeal's finding that the links to the Pandey case or the analogies with it were not sufficiently strong, we dealt with that in our case at 12.2, which I respectfully refer the court to. I think I did. It's page 2817, but we say that there is ample material on the basis of which one can establish a parallel risk in this case. These were UNC, these were defendants identified with the UNC, the opposition party to the Attorney General. It was a politically charged case. A finance minister was one of the defendants. Two financiers of the UNC, Ferguson and Galbraith Singh, were two of the other defendants. And Smith and Gomes were officers of one of Mr. Ferguson's companies, the maritime company, identified with Mr. Ferguson. And so we would say that if one's saying, well, is there any particular reason to think that there was an adversarial political directorate in this case, as in Pandey, then the answer is yes. And so that in our respectful submission, there's quite clearly sufficiently strong analogies with the Pandey case that one's not just saying that because he's a prosecutor, he'll like to see people being convicted. One's saying there are extraneous matters to do with political affiliations, which were well known, and if they might have operated in Pandey, then they might well have operated in this case. As to the approach that was adopted about it's really the baseline approach that my Lord Lord Sales put to my learned friend. It does appear in our respectful submission that that's exactly what the judge did do. He said, well, you didn't take the point in July, so we'll, as it were, operate on the basis that there wasn't anything in July, and then we'll see whether there was enough after that. And then he looks, so we say that's the wrong approach, because you have to look at the picture, the overall picture in December, which included the Pandey and Virgil findings and everything that had gone before. And then when it came to answering the question, well, did the events that post-dated July add anything, they completely ignored the fact that the JLSC had said that he should be injuncted from further hearing, and that he only, as it were, carried on because of his judicial review. So that if, as it were, the touchstone of whether a judge should be acting is the JLSC, they were saying he should be, I'm sorry, it's not injuncted, it was...
interdicted.
Suspension. Interdict, I think.
Yes, interdicted. So that was their view. He should not be sitting. And then Lord Mustill's tribunal, as has been put to my own friend, it made all the difference in the world. The idea that it was just more of the same is in our respectful submission, wholly irrational, when what he did was to make admissions essentially of accepting a payment from a witness and banking it, and then only doing something about it when he thought he was detected by the bank. So those are our submissions on those 2 points, 12.2 and 12.3 of our case. The volte-face point, can I just deal with it in this way? Very often in these cases you say, well, you make an allegation of bias, but look at the way the judge behaved. He behaved with impeccable fairness throughout. And if you then look at the case and you say he acted with conspicuous unfairness throughout, you say, well, that fits in, as my Lord Hodge put, fits in with a pattern. And we do say that, can I just give you the reference? Because it is...
Just on this, presumably, since there was a judicial review by at least some of the defendants of the decision, there was evidence from the Chief Magistrate to explain his decision.
I think it was an issue of law, whether you could add additional. My Lord,
anyway, can that be looked into?
Of course,
my Lord. We need to know
that. Yes, whether it was proper, but your Lordship maybe. But all I'd respectfully submit is, if you look, and I know this isn't the complete answer, we will provide a more comprehensive answer. But if you look at Volume 5, page 1549, there is no doubt that there he says to the defence, you needn't answer the amended charges. It's there in black and white.
All right, I don't want to prolong this unnecessarily, but I rather had the impression from that the Chief Magistrate at that stage was trying to constrain and limit the argument that he was going to listen to on that occasion.
Yes.
And he didn't want the Defence Counsel getting into the new additional charges for whatever reason. He just didn't want to deal with that on that occasion.
Well,
I mean, the counsel that he is, who are his interlocutors, are counsel for the defence.
Yes,
so they keep saying, and can we deal with the possible new charges, which had already been put on the table, if you like, in October, and for whatever reason, and I haven't been back through the whole transcript.
Yes.
The magistrate doesn't want to use that hearing to deal with those matters, but as I was indicating before, it does seem that there were written submissions later where the issues were ventilated again, but you're going to help us with that.
Well, we're going to. Can I just indicate, my Lord, at the bottom of page 1549, one sees the state indicated there. The Chief Magistrate says the state indicated they are no longer proceeding with this application. So there is nothing for the court to rule upon. So it is withdrawn. It is withdrawn. So certainly that's the position then. I accept that we'll have to make.
But that was on that occasion.
Yes, yes.
It seems, I think, pretty clear that the state did make an application later on and in effect did invite the magistrate to rule, and then he did rule.
Well, on the 8th of February, the defence put in submissions relating to the original charges. And then your lordship's quite right. On the 26th of February, the prosecution put in a reply. We don't know what.
Anyway.
Oh, they didn't. You'll see these documents anon.
Yeah, well, there's the 8th of February. These are all dealt with in the Chief Magistrate's affidavit himself. He sets out the history of what happened. So if you look at his affidavit, he describes the order in which there were representations. But, my lords, I of course accept that the court would be assisted by having it definitively established. But that, in a sense, if I can put it bluntly, is a codicil, because it helps the overall picture if he acted unfairly. But he certainly acted unfairly when he came to deal with the recusal application. He gave absolutely no reason for his decision. He dealt with it in a summary and dismissive way on the 8th of January. He didn't even deal with the point that at least postpone any further participation in this until the disciplinary bodies pronounced. And he dismissed the constitutional motion as frivolous and vexatious. So even if you set aside and say that what we've described as the volte-face was either not a volte-face or was legitimate, you still have his conduct on the 8th of January, and you still have the appearance of bias made out by a whole host of indications that he was beholden to the Attorney General. My learned friend very fairly hasn't. I don't think he's really responded to. He hasn't suggested that he wasn't beholden in the ways that we've set out in the submissions relating to the Attorney General's series of interferences in the case, both to help in relation to the repayment of the 400,000, both in relation to the conflict with the Chief Justice where he stepped in, and supporting the Chief Magistrate in not testifying. Now, the suggestion was, well, these interventions were a long time before, but actually that's not true. It's true. It's right that the intervention in May 2006 was some considerable time before the recusal application in December 2007. It's right that the intervention to stop the inquiry into the magistrate's behaviour was in 10th of May 2006. But the intervention to support the Chief Magistrate in his refusal to testify was in February 2007. And so that is in the same year as the disputed ruling in July of that year. And then one has, after that, the interdiction decision, the evidence in the Mustill Tribunal and the report of the Mustill inquiry. So there were matters coming in all the time, which deepened the evidence of how far the Chief Magistrate.
I'm going to have to press you, Mr. Fitzgerald. We have these points.
Yes, yes,
the time is up, unless there is something burning that you need to, one thing you need to say.
My Lord, I think that those really are the points. The only further matter then is to put put in writing the chronology, the composite chronology, and also we'll deal with the issue of what happened to the statement by the Chief Magistrate. You needn't deal with the amended charges and what happened in particular, as I understand it, the 26th of February, where the prosecution put in their submissions. What did they, as it were, revive the issue of the amendment there? And that, as I understand, what my Lord of Sales would do.
Those are the action points, as I understand.
Yes.
But that might not be the complete picture.
No.
We're asking for the complete picture. That's just to show we certainly haven't got it all.
One other question, if I may. You mentioned Mr. Ferguson having some connection with the other opposition party. Is there some reference you'll be able to give us for that?
Well, he was alleged to be a UNC financier, yes.
Yeah, well, I don't. I mean, I'm not sure whether that's in the statement of facts or the anywhere. So perhaps you could. I'll ask you for it now, but I'm just asking if you could add that to the.
Yes. Well, we will provide all those points if that assists.
Yeah, and if it can be agreed with Mr. Rowe, that would be very helpful.
Yes, of course. Yes. Thank you, my Lord. I'm very grateful.
Thank you. Well, the board is very grateful to counsel for their assistance in this interesting matter. We're also very grateful to those who have assisted counsel in assembling the papers and in the preparation of the case. The board will take time to consider their judgment.